Hello and welcome to my channel Patel Legal Updates. Today I am going to teach you chapter number 3 of BNS, which generally deals with general exceptions from section 14 to 44. So let's start with the section 14, which generally deals with act done by a person bound or by mistake of fact believing himself bound by law. Nothing is an offense which is done by a person who is or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. Illustrations. A. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law. A has committed no offense. B. An officer an officer of a court being ordered by that court to arrest Y and after due inquiry believing Z to be Y, arrest Z. A has committed no offense. Section number 15 deals with act of judge when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Section number 16. Act done pursuant to judgment or order of court. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court if done whilst such judgment or order remains in force is an offense, notwithstanding the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. Section number 17. Act done by a person justified or by mistake of fact believing himself justified by law. Nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing it. Illustrations. A sees Z commit what appears to A to be a murder. A, in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murderers in the fact, seizes Z in order to bring Z before the proper authorities. A has committed no offense, though it may turn out that Z was acting in self-defense. Section number 18, which generally deals with accident in doing a lawful act. Nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Illustration. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Section number 19. Act likely to cause harm but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Explanation. It is a question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that it was likely to cause harm. Illustrations. A, the captain of a vessel, suddenly and without any fault or negligence on his part, finds himself in such a position that before he cannot stop his vessel, he must inevitably run down a boat. B, with 20 or 30 passengers on board unless the changes the course of his vessel, and that by changing his course he must incur risk of running down a boat C with only 2 passengers on board, which he may possibly clear. Here, if A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passengers in the boat B, he is not guilty of an offense, though he may run down the boat C by doing an act which he knew was likely to cause that effect, if it be found as a matter of fact that the danger which he intended to avoid was such as to excuse him in incurring the risk of running down the boat C. B. A, in a great fire, pulls down houses in order to prevent the conflagration from spreading. He does this with the intention in good faith of saving human life or property. Here, if it be found that the harm to be prevented was of such a nature and so imminent as to excuse A's act, A is not guilty of the offense. Section number 20. Act of a child under 7 years of age. Nothing is an offense which is done by a child under 7 years of age. Section number 21. Act of a child above 7 and under 12 years of age of immature understanding. Nothing is an offense which is done by a child above 7 years of age and under 12 years of age who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Section number 22. Act of a person of unsound mind. Nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Section number 23. Act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section number 24. Offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Section number 25. Act not intended and not known to be likely to cause death or grievous hurt done by consent. Nothing which is not intended to cause death or grievous hurt and which is not known by the doer to be likely to cause death or grievous hurt is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Illustrations. A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play, and if A while playing fairly hurts Z, A commits no offense. Section number 26. Act not intended to cause death done by consent in good faith for person's benefit. Nothing which is not intended to cause death is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith and who has given a consent, whether express or implied, to suffer that harm or to take the risk of that harm. Illustration. A surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under the painful complaint but not intending to cause Z's death and intending in good faith Z's benefit, performs that operation on Z with Z's consent. A has committed no offense. Section number 27. Act done in good faith for benefit of child or person of unsound mind by or by consent of guardian. Nothing which is done in good faith for the benefit of a person under 12 years of age or person of unsound mind by or by consent either express or implied of the guardian or other person having lawful charge of that person is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to that person, provided that this exception shall not extend to a. the intentional causing of death or to the attempting to cause death, b. the doing of anything which the person doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. C. The voluntary causing of grievous hurt or to the attempting to cause grievous hurt unless it be for the purpose of preventing death or grievous hurt or the curing of any grievous disease or infirmity. D. The abatement of any offense to the committing of which offense it would not extend. Illustration. A. In good faith for his child's benefit without his child consent has his child cut for the stone by a surgeon knowing it to be likely that the operation will cause the child's death but not intending to cause the child's death. A is within the exception in as much as his object was the cure of the child. Section number 28. Consent known to be given under fear or misconception. A consent is not such a consent as is intended by any section of this Sanhita. A. If the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in a consequence of such fear or misconception, or b. if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and consequence of that to which he gives his consent, or c. unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. Section number 29. Exclusion of acts which are offences independently of harm caused. The exceptions in section 25, 26 and 27 do not extend to acts which are offences independently of any harm which they may cause or be intended to cause or be known to be likely to cause to the person giving the consent or on whose behalf the consent is given. Illustration. Causing miscarriage unless caused in good faith for the purpose of saving the life of the woman is an offense independently of any harm which it may cause or be intended to cause to the women. Therefore, it is not an offense by reason of such harm and the consent of the woman or of her guardian to the causing of such miscarriage do not justify the act. Section number 30 deals with act done in good faith for benefit of a person without consent. Nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith even without that person's consent if the circumstances are such that it is impossible for that person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent in time for the thing to be done with the benefit, provided that this exception shall not extend to a. the intentional causing of death or the attempting to cause death, b. the doing of anything which the person doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity, c. the voluntary causing of hurt or to the attempting to cause hurt for any purpose other than the preventing of death or hurt, d. the abatement of any offense to the committing of which offense it would not extend. Illustrations. 1. Z is thrown from his horse and is insensible. A surgeon finds that Z requires to be trepaned. A, not intending Z's death but in good faith for Z's benefit, performs the trepan before Z recovers his power of judging for himself. A has committed no offense. 2. Z is carried off by a tiger. A fires at the tiger, knowing it to be likely that the shot may kill Z, but not intending to kill Z and in good faith intending Z's benefit. A's bullet gives Z a mortal wound. A has committed no offense. 3. A surgeon a surgeon sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply to the child's guardian. A performs the operation in spite of the entreaties of the child, intending in good faith the child's benefit. A has committed no offense. 4. A is in a house which is on fire with Z. A child. People below hold out a blanket. A drops the child from the housetop, knowing it to be likely that the fall may kill the child but not intending to kill the child and intending in good faith the child's benefit. Here, even if the child is killed by the fall, A has committed no offense. Explanation: mere pecuniary benefit is not benefit within the meaning of section 26, 27 and this section. Section 31, communication made in good faith. No communication made in good faith is an offense by reason of any harm to the person to whom it is made, if it is made for the benefit of that person. Illustration: a surgeon in good faith communicates to a patient his opinion that he cannot live. The patient dies in consequence of the shock. He has committed no offense, though he knew it to be likely that the communication might cause the patient's death. Section number 32, act to which a person is compelled by threats murder and offense murder and offense against the state punishable with death. Nothing is an offense which is done by a person who is compelled to do it by threats which at the time of doing it reasonably cause the apprehension that instant death to that person will otherwise be consequence, provided that the person doing the act did not of his own accord or from a reasonable apprehension of harm to himself, short of instant death, place himself in the situation by which he became subject to such constraint. Explanation 1. A person who, of his own accord or by reason of a threat of being beaten, joins a gang of dacoits, knowing their character is not entitled to the benefit of this exception on the ground of his having been compelled by his associates to do anything that is an offense by law. Explanation 2. A person seized by a gang of dacoits and forced by threat of instant death to do a thing which is an offense by law. For example, a smith compelled to take his tools and to force the door of a house for the dacoits to enter and plunder it is entitled to the benefit of this exception. Section number 33, act causing slight harm. Nothing is an offense by reason that it causes or that it is intended to cause or that it is known to be likely to cause any harm, that if that harm is so slight that no person of ordinary sense and temper would complain of such harm. Section number 34. From section number 34 to 44 generally deals with the right of private defense. So section number 34 deals with things done in private defense. Nothing is an offense which is done in the exercise of the right of private defense. Section number 35, right of private defense of body and of property. Every person has a right, subject to the restrictions contained in section 37, to defend A, his own body and the body of any other person against any offense affecting the human body. B, the property, whether movable or immovable, of himself or any other person against any act which is an offense falling under the definition of theft, robbery, mischief or criminal trespass, or which is an attempt to commit theft, robbery, mischief or criminal trespass. Section number 36, Right of private defense against act of a person of unsound mind, etc. When an act which would otherwise be a certain offense is not that offense by reason of the youth, the want of maturity of understanding, the unsoundness of mind, or the intoxication of the person doing that act, or by reason of any misconception on the part of that person, every person has the same right of private defense against that act which he would have if the act were that offense. Illustrations: A. Z. A person of unsound mind attempts to kill A. Z is guilty of no offense, but A has the same right of private defense which he would have if Z were same. If Z were sane. B. A enters by night a house which he is legally entitled to enter. Z in good faith taking A for his housebreaker attacks A. Here Z by attacking A under this misconception commits no offense, but A has the same right of private defense against Z which he would have if Z were not acting under that misconception. Section number 37. Act against which there is no right of private defense. 1. There is no right of private defense A against an act which does not reasonably cause the apprehension of death or of grievous hurt if done or attempted to be done by a public servant acting in good faith under color of his office, though that act may not be strictly justifiable by law. B. Against an act which does not reasonably cause the apprehension of death or of grievous hurt if done or attempted to be done by the direction of a public servant acting in good faith under color of his office, though that direction may not be strictly justifiable by law. C. In cases in which there is time to have recourse to the protection of the public authorities. 2. The right of private defense in no case extends to the inflicting of more harm than it is necessary to inflict from the purpose of defense. Explanation 1. A person is not deprived of the right of private defense against an act done or attempted to be done by a public servant as such unless he knows as has reason to believe that the person doing the act is such public servant. Explanation 2. A person is not deprived of the right of private defense against an act done or attempted to be done by the direction of a public servant unless he knows or has reason to believe that the person doing the act is acting by such direction, or unless such person states the authority under which he acts, or if he has authority in writing unless he produces such authority if demanded. Section number 38. When right of a private defense of body extends to causing death. The right of private defense of the body extends under the restrictions specified in section 37 to the voluntary causing of death or of any other harm to the assailant if the offense which occasions the exercise of the right be of any of the descriptions hereinafter enumerated, namely: A. Such an assault as may reasonably cause the apprehension that death will otherwise be the consequence of such assault. B. Such an assault as may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such assault. C. An assault with the intention of committing rape. D. An assault with the intention of gratifying unnatural lust. E. An assault with the intention of kidnapping or abducting. F. An assault with the intention of wrongfully confining a person under circumstances which may reasonably cause him to apprehend that he will be unable to have recourse to the public authorities for his release. G. An act of throwing or administering acid or an attempt to throw or administer acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such act. 39. When such Section 39. When such right extends to causing any harm other than death. If the offense be not of any of the descriptions specified in section 38, the right of private defense of the body does not extend to the voluntary causing of death to the assailant, but does extend under the restrictions specified in section 37 to the voluntary causing to the assailant of any harm other than death. Section number 40. Commencement and continuance of right of private defense of body. The right of private defense of the body commences as soon as a reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense, though the offense may not have been committed, and it continues as long as such apprehension of danger to the body continues. Section number 41 deals with when right of private defense of property extends to causing death. The right of a private defense of property extends under the restrictions specified in section 37 to the voluntary causing of death or of any other harm to the wrongdoer if the offense, the committing of which or the attempting to commit which occasions the exercise of the right be an offense of any of the descriptions hereinafter enumerated, namely A. Robbery, B. Housebreaking after sunset and before sunrise. C. Mischief by fire or any explosive substance committed on any building, tent or vessel, which building, tent or vessel is used as a human dwelling or as a place for the custody of property. D. Theft, mischief or house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequence if such right of private defense is not exercised. Section number 42. When such right extends to causing any harm other than death, if the offense, the committing of which or the attempting to commit which occasions the exercise of the right of private defense be theft, mischief or criminal trespass, not of any of the descriptions specified in section 41, that right does not extend to the voluntary causing of death but does extend, subject to the restrictions specified in section 37, to the voluntary causing to the wrongdoer of any harm other than death. Section number 43. Commencement and continuance of right of a private defense of property. The right of private defense of property A commences when a reasonable apprehension of danger to the property commences. B. Against theft continues till the offender has effected his retreat with the property or either the assistance of the public authorities is obtained or the property has been recovered. C. Against robbery continues as long as the offender causes or attempts to cause to any person death or hurt or wrongful restraint, or as long as the fear of instant death or of instant hurt or of instant personal restraint continues. D. Against criminal trespass or mischief continues as long as the offender continues in the commission of criminal trespass or mischief. E. Against housebreaking after sunset and before sunrise continues as long as the house trespass which has been begun by such housebreaking continues. Section number 44 deals with right of private defense against deadly assault when there is risk of harm to the innocent person. If in the exercise of the right of private defense against an assault which reasonably causes the apprehension of death, the defender be so situated that he cannot effectively exercise that right without risk of harm to an innocent person, his right of private defense extends to the running of that risk. Illustration: A is attacked by a mob who attempt to murder him. He cannot effectively exercise his right of private defense without firing on the mob, and he cannot fire without risk of harming young children who are mingled with the mob. A commits no offense if by so firing he harms any of the children. So please like, share and subscribe to my channel if it is useful for you. Thank you.